uh, a rocket going up.
Hello, everyone. Hello, everyone, and welcome to our webinar. My name is Abigail Moy, and I am the Director of the Global Legal Empowerment Network at MATI. I'm pleased to be facilitating today's webinar. It's Wednesday, May 31st, and today we have come together for a 90-minute webinar that will focus on real-life experiences with professionalizing paralegals in South Africa, India, and Sierra Leone. We're joined by Vivek Maru and Songkita Konte from Namati, Gagan Sethi from Center for Social Justice, and Simbongile Kamche from Akaosa. My network team colleagues, Tobias Eigen, Ashley Van Wees, Michael Otto, Maya Redding, and Caitlin Tucker will be fielding your questions and taking live notes. Please refer to the chat box for the link to the Google document in which we will be transcribing live notes. We can take a moment right now for everyone who's helping to organize this webinar to say hello and wave to the participants that have joined us. Hello, everyone. You can see our faces waving at the top of your screen. All right, I'm going to continue. Before we get too far into today's proceedings, I have some brief housekeeping. Firstly, take note that this event is being recorded, and we will share the full recording and highlights later on our website. I also want to make sure you can hear well and are able to use our webinar system. You will see a question pane where you can type in your questions and communicate with us on your screen. There's also a button for raising your hand to get our attention. It has a symbol of a hand on it. I'd also like to introduce you to the Global Legal Empowerment Network. The network is a growing community of more than 1,000 organizations and 4,000 practitioners from around the world who are working to advance justice. We are human rights activists and grassroots organizers, lawyers and community paralegals, anyone who's working across all regions and all disciplines. What ties us together is that we are all working to help communities know, use, and shape the law. Through the network, we come together to collaborate and learn from each other. How do we do this? The main way the network members connect is through an online discussion forum, which you can access from your laptop, tablet, or smartphone. Here, we discuss problems and share ideas, solutions, and opportunities. We also learn from one another through webinars like this one, and in face-to-face learning exchanges, leadership courses, and other events, all of which we announce on our discussion forum. Additionally, there's our online library, which today has more than 1,000 free legal empowerment resources, such as training materials, monitoring and evaluation tools, case management forums, academic research, and more. Last but not least is advocacy. We work together to campaign on issues that affect us globally and nationally. Our latest campaign helps ensure the United Nations Sustainable Development Goals included a goal specifically on access to justice. You can join the network by clicking on the link on your screen. It's in the chat pane. Membership is free and open to all. Just complete a sign-up form on our website and you're in. We will be getting in touch with all of you after the webinar with a link to invite you to join. Once you're signed up, we'll be able to update you when useful resources and opportunities arise. One resource in particular will be of interest to participants in this webinar. In the coming weeks, we will be launching a toolkit on paralegal recognition, which will include a series of research briefs that review, country by country, the nature of the work undertaken by community paralegals and the extent to which that work is recognized and funded by government. The toolkit will also include analysis and examples of laws relating to the professionalization of paralegals. We're excited to share this toolkit with network members, and we hope you'll find it useful. Before we begin, I do want to take a moment to share with you some sad news. One of the members of our Network Guidance Committee, Nomboniso Macbela, has recently passed. She was an incredible human being and a leader of our movement. She guided our network since the very beginning, and to this day stands as an inspiration to all legal empowerment practitioners around the world. I just wanted to take a brief moment of silence in honor of her memory as we try our very best to honor her legacy through our work. Thank you, everyone. This webinar would have been very special because the professionalization and institutionalization of paralegals was an issue that was very important to Nomboniso. And you'll hear from her colleague, Simbongile, about all of the amazing work that they've done in South Africa to advance the status of paralegals in their country. Now on to today's event. We have three fascinating presenters today. Each will speak for 10 minutes. Please type in your question in the questions pane as we move along. We will collect them and do our very best to answer every question. There will be time after the presentation to pose some questions to the presenters directly. Time permitting, we also plan to give the floor to participants. Let us know via the questions pane if you'd like to be unmuted and the questions or topics you'd like to talk about. To begin, I'm very pleased to introduce Vivek Maru, who will be moderating today's webinar. Vivek, over to you.
And thank you, everybody, for being here. We have a really important topic, and as Abby said, one that was dear to Nomboniso's heart, and it's professionalization. The movement for legal empowerment really has its roots in activism. Paralegals started out helping people survive apartheid in the 1950s, and in the Philippines, paralegals began as part of the resistance to martial rule. As legal empowerment movements have matured, though, many of them have sought to professionalize with common standards for training, accreditation, and quality. We've often looked to the public health movement for inspiration, and in public health, you certainly have doctors, but you don't just have doctors. You have nurses and midwives and community health workers in many countries, and often each of these rungs of the healthcare delivery system has some standards for training, for accreditation, for ethics. They have professional associations, they have institutions dedicated to them. They are recognized by the state for the specific roles they play. And so those of us working on legal empowerment have sought in recent years to emulate that level of standardization. On the other hand, there is a way in which the analogy between legal empowerment and healthcare breaks down, which is that legal empowerment is about holding governments accountable. about holding powerful interests accountable. And because of that key difference, this move to professionalize, to standardize, to regulate also poses risks to the independence of paralegals and to the ability of legal empowerment efforts to undertake that key role. So I think one of the questions that we face is whether we can maintain the dynamism and the passion and the soul of what we do, while at the same time raising standards, increasing legitimacy, and increasing scale. And so really a topic that really cuts to the heart of where our movement is headed. And we've got three awesome people to talk about it with. Sankita Conte from Nemati, Sierra Leone, Gagan Sethi from Center for Social Justice. Gagan Bhai has been a paralegal himself, as he will describe, since the 1970s, and founded many legal empowerment organizations in India, including the Center for Social Justice. And Sibongile Kamche from the Association of Community Advice Offices of South Africa, which, as I mentioned, is really, as far as we know, the oldest tradition of community paralegals on earth. And so we are looking to South Africa for leadership as we explore this new frontier. I will say that we've got over 200 people from 50 countries registered for the webinar, which is a record for us, which just gives you a sense of how important this set of questions is to our whole community. And before we got started, we were just going to do a quick poll to get a sense of the folks in the room. It should pop up on your screen. And basically the question is, we're giving 4 options and asking you which of these best describes your attitude towards professionalization. Option 1 is that you're wary and your sense is that the risks outweigh the benefits. Option 2 is that you're on the fence but keen to learn more. Option 3 is that you're sure we do need to professionalize and you're just trying to figure out exactly how to go about professionalizing. And then option 4 is that in our context, we have already established a strong profession for community paralegals. So if you could just click one of those 4 options, then it'll help us, and we'll share with the speakers to get a sense of where people are at. While you're doing that, I will turn it over to our first speaker, who is Sibongile. Sibongile, you need to unmute yourself. There should be a button. We can't hear you yet.
Okay, can you hear me now?
Yes, perfectly. Good to hear you. All right.
Now, am I correct to understand that the slides are being controlled from somewhere, and then somebody is navigating the slides? I'll just be talking from the screen.
That's correct. Just say next slide when you're ready.
Okay, I would like to see the next slide. In fact, I would like to see the presentation in the first place. Abigail? Abigail? Hello?
Go ahead and begin.
Yes, I need to see the first slide.
Yes. Can you take down the quick poll results, Ashley, and start with the slide?
Before you begin, I would just say that the results from the poll came in, and 49% of our participants said we need to professionalize, and I'm eager to figure out how. And 38% said we're on the fence, keen to learn more. 4% said they were wary. 9% said we've already done this. We've already established a strong profession. So we're basically in the middle of the 2 extremes. But yeah, we're turning on the slides, and I'm turning it over to you.
Good. All right. Many thanks to the Global Legal Empowerment Network and to the donor community associated with the community. And thanks to everybody who is here and everybody who is watching from the background, this presentation. This is an effort to present exactly what we are doing in South Africa towards the whole notion of regulation, recognition, and standardization and professionalization. We will be talking to the experiences and the lessons. I do want to indicate that in the South African context, that community paralegals that we are working with are community-based paralegals. There is a broad range, there's a fairly wide range of paralegals in South Africa that we'll be talking about in the next coming slides. And that as a result, we don't strictly refer to ourselves as the paralegal sector. We call ourselves the Community Advice Office sector, because upon its establishment in 2013, ACAOSA had agreed that the focus is on creating institutions, community-based institutions. And so therefore, the paralegals, we have paralegals that are based in communities and that have a certain orientation that is speaking to that background that Vivek was talking about around activism, and which also connects to the history in the fight against apartheid. But also we are very focused on the idea of standardization, institutionalization, and paralegals. We can move to the next slide, please. Next slide. Thank you. This slide presents, no, the previous one. The previous one. Yes, that's this one, thank you. In this slide, we basically present how we define a community-based paralegal, being a person or persons who hold themselves out to be paralegals and who are qualified by education, training, and or work experience, and who volunteer or are employed by community advice offices. This definition comes from the draft bill that ACAOSA has been working on with other stakeholders. We have two sets of documents. We have the draft bill, we have an internal regulatory instrument of ACAOSA, and you might find that in some way, the definition in the internal regulatory instrument, it goes further to talk about people who are rendering services to indigent or poor people who are otherwise marginalized by dint of a location or means. But that definition goes to the next slide, where we discuss, they define the community-based advice office. Please, let's move to the next slide. This is the slide that defines the community-based advice office. The community-based advice office is basically an office in the communities. In terms of its governance arrangements, community members would be in its management, governing, or advisory boards. These are voluntary institutions that in most cases are struggling for resources, but they are owned by communities and they are very responsive to the issues within the communities. Their focus is around the empowerment, advice, and social justice to the people. And the people being those who are indigent or are by reason of social circumstance unable to afford the services of a legal practitioner. And these services are rendered by community-based advice offices at no cost. We'll talk further around this question of no cost in the next slides. Please, let's move forward. Next slide, please. This here is an attempt to project what type of services are to be found in community advice offices. If you look, you will notice that it's quite a broad range of issues. In fact, the debate emerges when we were discussing the question around the funding modalities for advice offices, whether we should have a franchise model that defines, that packages what type of services an advice office should have. And then you, as an advice office, you buy into that package, not in the literal sense of buying, but we then agree that we don't want to constrict what people can do. Advice offices must respond to the context within communities, must help to resolve the problems that are in communities. But this is a representative sense of what basically communities are doing. Since 1994, the focus has been more on government services, has been more on connecting communities to the new state that emerged after 1994. There are issues that speak to mobilizing communities. There are issues that speak to building community structures, but there is still that package that speaks to the problems that somebody comes around gender-based violence, around issues of estates, wills, etc. This basically is an attempt to define what advice offices in South Africa in the main are doing. Thank you. Let's move to the next slide, if no questions. Any questions, please, at this stage? Next slide. Thank you. In terms of the paralegals at large in South Africa, we define where they are to be found here. In this sense, we have community-based paralegals that are found in community advice offices, and they are thus community-based paralegals. And then we have paralegals who are in the courts, either as clerks of the court. They are also in government departments, like in the Justice Department. They are also in legal aid South Africa, the justice centers spread around the country. We also have people who are operating in labor law consultancies and also as shop stewards in trade unions. We also have people who are assistants and clerks in legal practitioners firms, in attorneys firms, etc. We also have people who are self-employed as paralegals. In fact, these are the people who prompted us to move towards regulation, because we were getting afraid that all kinds of things are happening under the name of paralegalism. This is what prompted ACAOSA and its partners to move towards regulation. And then there is also that group of paralegals that are within the corporate environment, either in banks, insurance, in the insurance industry, etc. We know as well that the South African Police Service has been sounding an intention to bring on board paralegals. The point being that in many cases, justice is denied because police are struggling to write statements, and in many cases get botched at court because of how a statement just got to be written. So that basically is a sense of where do you find paralegals in South Africa. What we are talking about and for as ACAOSA is the first group, the ones that function in community-based advice offices. Thank you. Next slide, please. The community-based paralegals, and Vivek also mentioned that in South Africa, they have fairly a long history. I think it goes in some documents as far as 1937. Historically, they have their roots in the struggle against apartheid. And if we remember that law, as we know in South Africa, made a clear distinction between the white minority who were in power and the black majority. and hence law, as was understood, cast the image of blackness in the same box as informality and illegality. So the necessity arose to project a sense of the law that speaks to issues of justice, social justice, and also dealing with questions of the apartheid legacy. And for this reason, ACAOSA and its predecessor organizations understood the need for a cadre of paralegals that would be rooted in communities, that would empathize with communities, and that would be able to transcend the narrow boundaries and confines of legalism, so that they could help to deliver justice and facilitate resolution of conflicts within communities. Next slide, please. This here is a map that tries to show where paralegals, or at least the spread of paralegals across the 9 provinces of South Africa. This somewhat is a moving picture. Year on year, you find that this number is shifting upwards, downwards. What is reflected here is the number of advice offices that are members of ACAOSA. The coming slide will try to do a breakdown of the community advice offices across the board. It is important maybe to indicate here that in each advice office, you will find anywhere between 1 to about 6 practitioners. In some advice offices, where especially people are performing work related to extended public works for the Department of Cooperative Government and Traditional Affairs, you find in at least a few advice offices that they employ seasonally up to 90 people at any time. But the core of the staff is the community-based paralegals. Take your next slide. Maybe it is important, as we were still on the first slide, on the previous slide, to indicate that whereas all the community-based paralegals in South Africa are performing broadly the same type of work, but that type of work is informed also by location, geography, and context. For instance, in the Western Cape, you will find that in the Namakwaland West Coast and the Southern Coast, the Southern Cape, paralegals are mostly focused on work around farms. Some of you may be aware of the deterrence farm workers strike in 2012 in South Africa. It was quite a big strike. It led to what was supposed to be a sectoral determination on wages in the sector, but I don't want to discuss that here now. In the metro, Cape Town metro, you will find that people are, especially in all the provinces where you have urban areas and peri-urban areas, you will find that paralegals, community-based paralegals, are doing work in informal settlements around issues of housing, around issues of service delivery. Right now, we have we've had just a big protest around an informal settlement suburb of South Africa, Ennerdale, El Dorado, around housing. So this is the type of work that paralegals do. And so the context shifts as you go. Some are in very rural areas, and they do work with traditional leaders, and they do work around issues of ukutwala, which is the forced marriages that happen often, that we get to hear about. This slide, it presents a chart that speaks to the total number of advice offices. In total, we have 411, but the operational advice offices, the number is basically around 263, and 206 of which are ACAOSA members, 57 being non-ACAOSA members, but that number a number of them are beginning to join ACAOSA as they are beginning to see the work that we are doing around regulation and other stuff. And then you see that this is a breakdown between 2015 and 2016. That in 2015 we had 411 operational and 312 operational in as we move forward to 2015. Thank you. We can move to the next slide, please. Next slide. Thank you. This speaks to where we come from. And as we indicated earlier on, am I muted? Who is muted?
You're not muted. We can hear you loud and clear.
Can everybody hear me?
Yes, we can hear you.
Oh, thank you. All right, I heard somebody say muted. All right. Over a very long period of time, advice offices in South Africa have always operated under some form or other of umbrella body. Up until very recently, they were organized as paralegal associations. That means it was the paralegals that were organized, but after the formation of ACAOSA, they became community-based advice offices. It is also important to indicate that after the 1994 elections, when we had a new government, the new government promulgated what was called a Vision 2000, Justice Vision 2000, which was speaking to a transformed justice sector that was catering to all sectors of the population, and that sought to spread or that sought to create a wider justice network, and in terms of which paralegals would be part of the justice system. Towards this end, we saw the first attempt at passing a legal practice bill, which was going to recognize paralegals as belonging within the legal profession. And then we also saw the Legal Services Charter that was promulgated in South Africa. But then over time, it became clear that it was going to be difficult to regulate community-based paralegals or paralegals, all paralegals, together with the legal profession as understood as such. As a result, ACAOSA agreed that community-based paralegals must be regulated by a separate regulatory instrument. And in 2015, a position paper was developed that kind of tried to say, how do we want to be regulated? And then after that was adopted, there was a resolution towards drafting our own bill, which we have done. We are now engaging on the content of that bill with the state. We actually now have a task team that comprises the National Treasury, the Department of Justice, the Legal Aid Board, the Foundation for Human Rights, the Legal Resources Center, the law, I think I've mentioned Law Society, and other players. And at this stage, there is an agreement that this bill applies only to community-based paralegals and advice offices, because all other paralegals are regulated in terms of the employment arrangements that they have with the various institutions. There is also, I wanted to mention that the task team has been established, and that the Minister of Justice has since indicated that in terms of the medium-term strategic framework of 2017 and to 2019, their policy and legal program includes the promulgation of a law to regulate community-based paralegals. We also have a study that has been undertaken and funded by Open Society Foundation South Africa, which looks into possible funding modalities for the sector, which looks at how the state, together with the traditional donors, could come together to fund the sector. Thank you. Next slide.
Sibongile, I'll just jump in to say that we are over time, so if I could just ask you to conclude.
Okay, fine. This slide presents the purpose of the bill. I hope you can see it, which is to provide a legislative framework for regulation and professionalization of community advice offices, community-based paralegals, and also to provide for independence and to provide for the establishment powers and functions of the National Community Advice Offices Council, and in order to regulate community advice offices and to set norms and standards to provide for restoration of community advice offices and the certification and enrollment of community-based paralegals, so as to ensure accountable conduct and to provide for matters connected therewith. Next slide. Next slide, please. This slide here provides the key provisions of the bill, which is establishment of a CAO and a community advice office and community-based paralegal council, the requirements to operate a community-based operate as a community-based paralegal and to establish a community advice office. The question around case statistics, accreditation of training, general prohibition on charging of fees. No community advice office or paralegal will charge fees, independence and impartiality, and disciplinary provisions. Next slide, please. We're about to finish, if not finished. Next slide, please. Okay. I will just select a few of the lessons. One is now that this process of promulgation of a law is now between ourselves and a whole set of other stakeholders, and including the state, there is a threat that we might A, lose the momentum, but B, also the outcome might not exactly be to our liking. We are having to guard very jealously at this moment the independence of the sector. We are glad that we are moving forward. We are glad that we have had the support across the board from Parliament and into the government, the Deputy Minister. We've had champions of this sector. I've mentioned about the policy and legislative agenda of 2017-2019. Lastly, I want to express our deepest gratitude for the role played by the late Nomboniso. Abigail spoke to that, and also to indicate that as ACAOSA came about through the work of NATCAO, we have found it very useful that you had two organizations sitting in the same sector, and we're looking forward to continuing to work with NATCAO. And we've also enjoyed the support of the broader international community around paralegalism, like NAMATI, Open Society, CS Mode Foundation, and other organizations. And we'll continue to study what is happening elsewhere in order to enrich what we are doing here, even if we are the oldest, but we think we can learn from all of you out there. Thank you.
Thank you so much, Sibongile. We had a little mechanical error on our end, and we failed to give you a warning, but I'm going to turn it now to Gaganbhai. And Gaganbhai, if we could ask you to keep to 10 minutes just so that we have enough time for discussion at the end. We'll give you a little warning when there's 3 minutes left. Over to you. Gaganbhai, you're still self-muted, so you need to click a button to allow yourself to be heard.
Can I be heard now?
Yes, we can hear you, Gaganbhai. Great.
All right. Okay, I begin fast. Can you go to the next slide, please? I'm going to try and give you three big ideas in this whole discourse. My first big idea really is that especially those countries, including India, who have borrowed a legal system from the colonial British rule, is a design failure and a design disaster. My second big idea, which I want to say, is how there is need for an alternate model. And the third really is that there are specific things that we need to do to build this as an institutional alternative. My idea really, which I want to say, is that it was the British who designed this system. They were based in the 18th century with a population of 9 million, end of 19th century 41 million, and today they are 64 million. That is not even one state's population in this country. They are spending today, for every 10,000 inhabitants, they spend something like, there are 495 cases, that is about 0.05% who take legal services, and they spend 1,000 or 1,130 euros per person. Just to give you this idea, if I was to convert this into what India would have to spend if it wanted to give that kind of standards using the same system which we have taken, we would need 2 billion euros. I think each country should calculate, if you really want to make access to justice within the same framework, what is the kind of cost that the state would have to pay. There is another exclusion which is design. It assumes literacy of a high level. If you look at India, we have 74% literate today after 74 years. We started with 12%. But if you look at graduates, who are the only ones who can enter the legal profession, then we have 4% of scheduled caste, which is the lowest rung in our social hierarchy, and tribes, which are 3%. And therefore, it's unlikely that scheduled castes and tribes can even get into the legal system and therefore cannot represent. So therefore, it's by design an elitist concept, and therefore public representation is just not possible. Next slide, please. The next one. Yeah. Now, we had the old communitarian model, which was feudal, caste-based, but it was understood by all. The narratives we still have, the stories we still have, was imperfect, but we just threw it away, lock, stock, and barrel. The result today is that this present system is delay, corruption, quality, especially at the basic judiciary level, and sheer lack of resources to finance in this borrowed model. And the next slide is a picture which actually sums up almost everything of this point. Next slide, please. This is the Chief Justice of India weeping on national television, pleading to the Prime Minister for more resources, saying public confidence is an all-time low. This is a 3-month-old picture. And this should tell you what is really the inside story of what is happening. Next slide, please. I think if you look at we need to now move from paralegals to what I say paralegalism, which means we have to, as South Africa has done surely and showing very clearly, from practice to legitimization to institutionalization. That's the larger roadmap if we want access to justice, which all of us have signed on SDG 16, which means that it's inclusive, it's fast, it's inexpensive. And in India, we started sometime in the 70s, and it was largely the first training of what was called the animators, who got trained also with the use of law. And I think we learned a lot from Freire and the South American liberation theology. We attempted the first institutionalized model in the 90s, where at least about 25 organizations got together under the aegis of Indian Institute of Paralegal Studies. we trained 5,000 of them, supervised under Regional Resource Center, registered them as as an academic institution, and we led the first convention of all of them to Delhi, demanding that they have a specific role in different quasi-judicial bodies, women's commissions, land courts, etc. Next slide, please. And therefore, if we really need to look at paralegalism, therefore, we need to build the body of thought and the body of knowledge built out of the practice. Therefore, what was the practice of one-shot training to a systematic competency-based identity building, like what Vivek said in the beginning, like doctors and nurses. You build a body of knowledge based on narratives of practice and impact, showing very clearly that they can provide access, they can provide justice, and largely three big arenas: entitlements vis-a-vis the state, and we know that state offers a lot of schemes, a lot of this thing, but to access them needs support. Disputes, which take away the bulk of the court time, and even police, which is not supposed to be doing dispute resolution, is doing that, but that's a specialized role. And then violence and victims of violence who need access to justice from the court system. Though if you look at these three things, we have to see that academic institutions are involved in this whole process right from the beginning. We managed to get the National Legal Service Authority to use the term, but they only use it as a strategy way back in 2007. We got the Open University first to offer a diploma to people who have finished their 10th standards. Though we practiced it with illiterate women also, and by giving them basic training and bring them into the paralegal fold. We finally had a Nyay Panchayat, which is called in India a local governance system, which was supposed to hire paralegals. The fraternity, the legal fraternity, got extremely nervous that they were going to lose, and they brought in the village court system, which was just a top-down approach. It is now in the last year that we have started having the Legal Service Authority post SDG 16, where they've started appointing paralegals, but with very limited role of just awareness raising. Next slide, please.
I'll just jump in, Gaganbhai, to say you got 2 minutes remaining.
Okay, so would you go to then move on? Can you move on to the next slide again after this? I'll come to, can you go to the next slide, please? After this, move on. This is just the critique that we are doing. Next slide, please. Okay. All I want to now make the second big point. If we don't build the paralegal into the market system, we will never be able to bring legitimacy across the world. And therefore, a paralegal has to be able to, while working with NGOs also, but have to be also be able to charge fees. And I think this is the big shift. Otherwise, we will be always remain on donor money and things like that. And we need to move towards a sustainable system where we need thousands of them at the operational level who would charge and be able to then control, legitimize, standardize these issues. And that's where, the next slide please, we've built now a kind of Section 25 company. Next slide please. Yeah, I'll just take 2-3 more slides, the main ones, and then move on. Yeah, so this is what we then now looked at, and the idea is that we work together with a university, with a normal organization, a community-based organization, and work with paralegals in the whole business of legitimizing them, registering them, seeing that they are trained continuously, they are reporting their cases, and therefore they become, and they start charging so that the poor who pay are also holding them accountable. I think this is the next step where we need to move if we want to build the paralegalism as a profession in the entire access to justice ecosystem. Next slide, please. Yeah. So therefore, you have to design them literally as we have different models, which have multi-speciality centers, law centers, which have only issue-based. And then, if you go to the next slide, you will see the number of, can you go to the next slide? Yeah. So we have at the moment 19 of these centers, each one in each state working with a university and trying to register and train paralegals. So our business now is to create master trainers, not just in India, but across South Asia. And this we do with Bangladesh, the BRAC University and SAILS. And also I think Namati is part of that process. The idea being that it becomes a huge body of thought, it becomes a curriculum, and yet each NGO which uses them also has the autonomy. And I think some of the issues that we were raising of cannot take away their freedom, and those who want to be really passionate about social action, they are also part of that whole ecosystem. Next slide. Next slide, please. Okay. So largely the people who man these centers are from disadvantaged communities. And therefore, if you look at, we have at least 5 types of models. There, if you look at from the bottom up, the fellowship model, where there's an individual who runs his own or her own law center. We have an incentive model where 2-3 lawyers and 4 paralegals get together and look at an incentive-based system. We partner with CBOs, that is community-based organizations. Then we have some normal grant-based program models where we synergize the paralegals into them, and we run some as the company model itself to do our learning. Next slide, please. Okay, these are some of the things which are like, they have a common frame, they have a helpline, they have a client management system, a value charter. So it's actually therefore running it almost like a franchise system. And therefore they are recognized as the stop where people can go. Next slide, please.
Just to jump in, we're over time. I wonder if you could wrap up, and we'll come back to
all right,
discussion.
I'm wrapping up, and
okay.
My last point I would just say is, and maybe you can show the penultimate slide, is that therefore the entire training program is a capacity building program. Next, after this, is a capacity building program. We are against any one-shot process. There has to be a minimum of a 1-year process through which a person goes through, takes an oath like a doctor or a nurse, and therefore looks at not this as an add-on qualification, but as a profession to be, which is a lifelong profession for the person. That's, I think, the larger route to look at an alternate model. Thank you very much.
Thank you so much, Vivian, and thank you for bearing with my prodding. Great presentation and 2 very distinctive but complementary experiences. Let me turn it over to you, Samkita, and same thing, we'll give you a shout at about 3 minutes. We've got 3 minutes to go.
Oh, great. Thank you so much. Yes. I'll start off this presentation by giving a quick background to access to justice in Sierra Leone. And I would say here that access to justice, or the lack of access to justice, has been a national security issue for the country. Now, what you have in front of you is a quote, and it does paint a very gruesome picture of what the situation was like before the start of a 10-year civil war. The bottom line was that lack of access to justice was a major contributor to the almost 11-year civil war that the country suffered. And that resulted in the deaths of over 50,000 people, and thousands more were maimed in the process. That was not a pretty situation at all. And that was what we had to grapple with even after the war. Could you go to the next slide, please? So what happened was, when the war ended in 2002, after 11 years, we had a much more terrible situation. So if it was bad before the war started, it became much, much worse. The country was massively destroyed. Every facet of life was adversely affected. And justice systems, justice mechanisms were completely shot. Now, where do you start? That was a major question that we had to answer. Now, unfortunately, though, at the end of the Civil War, the concern for policymakers was mostly about addressing war-related justice issues. So, who were the persons who were responsible for the war, who were the individuals that committed atrocities. So they wanted to address those big picture international criminal justice issues. And unfortunately, they didn't pay attention to the key things, the grassroots justice concerns and challenges that really contributed to the war that we had for 11 years. And that was a major problem, because at the end of the day, we focused on establishing international justice mechanisms like the special courts and the Truth and Reconciliation Commission. We had help to build courts and police stations, but we did not have any significant partner helping us to address the issues of grassroots justice services. And the evidence was very clear for all to see that after the war, we had a very terrible situation. We had less lawyers in the country, most of them in the capital city. They were vastly expensive, and the population could not access those services. And so that was what we had to deal with. But then there was no policy, no mechanism in place to address the actual problems of access to justice. Could we go to the next slide, please? So in the midst of that, whilst the government and its partners were grappling with setting up of these international justice mechanisms, a gentleman came to Sierra Leone to test something. And that was the start of what I would call a social experiment at community-based justice provision. And around 2003, Vivek Maru came to Sierra Leone and wanted to see how civil society could respond to the access to justice gap in the country. And he had inspiration from countries like South Africa, where this model had worked in the past. And that was the beginning of an experiment, basically, to see how we could get non-lawyers into justice service provision by training them and deploying them in rural areas to use the agency of these communities and help resolve many justice challenges that they had at the time. So that was our attempt to answer the question, how do you respond to the justice challenges in a country that is recovering from a devastating civil war, where policymakers were not paying attention to grassroots justice needs? And that was how the whole concept of paralegals started in Sierra Leone. It was mainly a learn-as-you-go process. We were trying things out and seeing what works and what doesn't work. But then over the years, we began to develop tools and templates and the practice actually gained international recognition for the kinds of problems that it was solving in the country. Next slide, please. Now, as a result of these experiments from 2003 up to 2009, there was a lot of goodwill built and interest developed as well. And people began to talk about maybe there's something in this after all. What began as an experiment now gained momentum. And people wanted to see how it would work on a national scale. And so there were discussions to begin to talk about professionalizing paralegals, because whilst the experiment was happening, there was a bit of data collection going, and people saw the actual impact on the ground of this particular intervention. And so in 2009, that was the start of an attempt to make the paralegals more professional. And it began with a project that the Open Society Foundations, the World Bank, and a number of others are supported in partnership with the government. Now, one of the key things that project led to was the enactment of a law, the Legal Aid Act of 2012. Now, that law is reputed to be a very progressive one, and in the coming 3 slides, I'll quickly look at what are some of the things that the law puts in place to professionalize these experiments of paralegal service provision across the country. Could we go to the next slide, please? Now, the law sets up a mixed framework for legal aid provision, and in that framework, paralegals feature quite heavily. But then it also sets out certain mechanisms for making the process of primary justice service provision a bit more technical and formal. So apart from the fact that it recognizes paralegals now for the first time in the history of the country, it also sets about putting in place things to ensure that paralegals adhere to standards in the service provision. So there is a provision in the law that requires completion of a training course by the Judicial and Legal Training Institute or an educational institution, and that would lead to accreditation of the paralegal himself or herself. There's also provision for accreditation of organizations that are providing paralegal services. And the board, which by the way also has paralegals on it, or paralegal organizations on it, would also be looking at how to coordinate and evaluate legal aid services. Next slide, please.
Just to jump in and say you've got less than 3 minutes left, Funky Guy.
Okay. So the Act also talks about cooperation agreements, record keeping, like the things that paralegal organizations would need to do to keep their accreditation. And the board, largely is independent and should not be controlled by any person or authority. So it gives the board a bit of latitude to really go about this accreditation and professionalization in an independent way. Next slide, please. Of course, there are issues of financing, and then there is provision for those who do not want to comply with accreditation and other processes. There is a fine or the possibility of imprisonment for non-compliance with the accreditation processes. Next slide. Next slide, please. So the law is there. I mean, it's great. It's been shown to be quite progressive. But what has happened on the ground? Unfortunately, the board has not focused on building these systems, building these structures to ensure accreditation and formalization. Instead, the board has focused on itself providing legal aid services. And so that is a challenge at the moment for us. How do we get the board to really focus on these key issues that will be relevant for justice service provision across the country? And also the board suffers from lack of significant resources from the government, and one key institution that is required for the accreditation has not been legally set up. So even though we have a good law on the ground, nothing much has happened by way of building these mechanisms and ensuring that there is a process of accreditation. Next slide, please. However, and I don't want to sound pessimistic, however, change seems to be in the air, and the board seems to now want to take a new course. And so, with the assistance of Open Society Foundations, the board is taking a new direction and wants to build mechanisms. So, they are reviewing the strategic plan, which would now focus on building systems and formalizing paralegal service provision. So, it's not whole, it's not hopeless at the moment. There is change in the air. Next slide. Now, given the situation that we have a law and nothing much has happened on the ground, do we still think that professionalizing our paralegals is important? I would say yes, it is absolutely important, because one, we wanted paralegals to be recognized by the state, and with that comes certain responsibilities. So there has to be a trade-off. If you want recognition, there has to be a trade-off, because the state must be assured that paralegals are able to provide minimum services to the public. So that's one thing. I would argue that requires professionalization. So it's a trade-off: recognition for professionalization. And of course, I would also say that it affords paralegals the ability to access state institutions in an easier way, because in the past, before the law, paralegals had to negotiate their ability to, their access to institutions. But once you have a law that provides that recognition, it really helps in getting access to these, in resolving problems. And then, of course, we want to grapple with the issue of standardization. The law that I just referred to calls for paralegals in every chiefdom, which is a lot. So you would have many paralegals across the country, and you know that if you do have the numbers, there has to be systems in place. And then the last point on this would be, in Sierra Leone and in other places, we're looking to getting paralegals to specialize. And if they're specializing, there has to be some standards to which they could be held to in their work. Certainly there are risks, and the risks I have put up there for you to see. And if you do have questions about what I've just said, I'm excited for us to have a discussion. Thank you so much.
Thank you, Sankita, for a really rich presentation, and thank you to all three of you. Given that we're running short on time, I just want to jump straight in, because people have been writing in some really pertinent and thoughtful questions. One that came up from a couple people, both Claire Back. I'm not sure where you're from, Claire. If when you write in your question, if you just mention where you're from, then we'll give you a shout out. Both Claire Back and Helen Lang of Tanzania asked about, am I getting that right? Let's see. Asked about safety of paralegals. How do you protect them against threats? Would anyone like to speak to that?
Certainly, I could go, because I still see my mic on.
Please go ahead, Sankita.
Great. That is critical, and we do have situations where paralegals are up against vested interests, powerful corporations, and sometimes even against government. And so the thinking is that once you have a process that recognizes paralegals in a formal way, that would ensure that they are licensed to operate and they are able to draw comfort from that mechanism. Now, that said, I think it's also relevant to understand in our context that paralegals operate within an organization. So organizations are also, would also be thinking about steps or policies to ensure that their paralegals work in environments that minimize the risks that come with the charity and with the job. And the last thing I would say is that one of the things the paralegals have tried, and that did not have any input from organizations themselves, from those who run organizations, is that the paralegals have sought to organize themselves into an association. So it would be an association of paralegals across the country. And that could be a pressure group that could also play a part in pushing for better standards for paralegals as well as address safety issues. So even though the Act does not explicitly address the issue of safety, but we think that you could draw comfort from the fact that they're formalized and they're licensed to operate. That could provide some level of security. But that said, given the sensitive nature of some of the key things that they do, organizations would need to take steps as well to ensure that they operate in environments that minimize risks to them.
Thank you, Sonkita. Governor Boy, do you have anything to add on this question of protecting the safety of paralegals against retaliation?
No, just two lines. It's a high-risk job. There is no question about it. I mean, most of their front lines were taking on establishment, and therefore the need for an institutional support, and that the system outside must know that this is not an individual, and there's a huge backing of an institution system, both in terms of association, in terms of the people who hire them, that they would have to take on the whole system also as a counter system if they try and get funny with them. So I think, plus of course we do the normal listing of accident insurance and health insurance. These are also in a sense add-ons to the security system. So they need to have their own social security base, even financially.
Excellent, thank you, Gagan Bhai. Sibongile, a couple questions for you.
Okay.
Jargal Saikan Kunan from Mongolia was interested in a little bit more detail on accreditation of trainings. How do they happen? Have you managed to get, how does accreditation happen? From whom? Have you managed to get any government funding for paralegal training? And Jargal Saikan is also wondering if you could share the draft bill with this group. And then relatedly, both Natalia Kamburian of Moldova and Hassan Sise of Sierra Leone were curious about self-employed paralegals. Could you say a bit more about how they operate and how they make a living, and whether they are certified in any way? And then lastly, if you could just clarify the distinctions between a CAO, a CBP, and a COSOA. If you could just sort of reiterate the definitions and clarifications of each of those. That was a question that Natalia had.
Thank you, Vivek. Around the accreditation, I will say first that we have what we call the SETA system, Sector Education and Training Authorities in South Africa. They operate across different sectors. We have that one that operates around what we call the SASETA, that operates around security, and that also operates around issues of legal services. And it offers accreditation to the courses, but also the universities themselves. They also can offer in-house accreditation of their own offerings in terms of the trainings that they provide. We have what we call the Justice College. It also offers accredited training in the South African context. In terms of the proposal from the bill, is that the new Council of Community Advice Officers and Community-Based Paralegals, that council will accredit training for community advice for community-based paralegals. As it stands now, we have an organization called CCJD, Center for Community Justice and Development in Pietermaritzburg, KwaZulu-Natal. It works with the University of KwaZulu-Natal to do recognition of prior learning work streams, so that people who have experience can then be trained through the University of KwaZulu-Natal. We also have the Cape Peninsula University of Technology, which is developing a Bachelor of Paralegal Studies. That they are working with us, and we have an arrangement that the first intake will come from community-based paralegals, especially that are working with us. Government funding for training. No, training as of now that is funded by the government. It comes through the Justice College. There is government funding for work of paralegals via departments like labor, social development, and others. But specifically, training is provided via the Justice College. Self-employed paralegals, yes, we have people are allowed to operate, practice their professions, but they are not within our fold. In fact, how they fund it themselves, they charge fees, and there have been many issues that have been raised against them, that sometimes they take money and then they disappear. But I don't want at this stage to paint everybody with one brush. But ACAOSA is cautious in terms of what is happening on that realm, in terms of, because there's no regulatory instrument. The question was asked, do you want these ones to be regulated? We said it will be difficult to regulate them together with community-based paralegals because the operating principles and tenets are very different. And then the community advice offices are institutions, usually small NGOs in communities that house community-based paralegals, individuals who either by training or by volunteering and over time taking some courses, they become community-based paralegals. ACAOSA is the voice organization. It is the association of community-based paralegals. Thank you.
Excellent. Thank you, Sibongile. I just wanted to flag a few resources that are in the pipeline that are relevant to this conversation. One is we have a book that we've been working on for a long time that has empirical studies of paralegal movements in 6 different countries. And one of the core questions that we wrestle with is institutionalization and the relationship between paralegals and the state. And that is coming out this year from Cambridge University Press. And we've arranged for it to be downloaded for free, available for free online. So look out for an announcement about that before the year is over. And then even sooner than that, we're going to be launching a guide to the way paralegals are recognized in legislation across many different countries, and that will be launching in the next few weeks. And then lastly, a couple people have asked about the specific bills that have been mentioned, the Sierra Leone bill, the South Africa bill, and we will make sure to circulate those to all the participants of the webinar after the webinar is over. Helen Lang of Tanzania asked a couple questions that I know come up a lot for our movement. One, she asked, what is the best way for systematically soliciting and learning from feedback from clients and from community? And I'm curious whether any of the 3 of you have worked on this in a systematic way and could speak to it. And then the second question she asked is about how to monitor and mitigate the risk of paralegals abusing their power by somehow taking advantage of their status or their reputation to exploit others. Would anyone like to speak to either of those?
Yes.
Gaganbhai, Sakita?
Vivek, I want to speak to the latter question.
Okay, go ahead, Sibongile.
Monitoring and minimizing risks of paralegals abusing their power.
Please.
The Deputy Minister of Justice here in South Africa, when we were developing the bill and we were presenting it to him in the ministry, he asked a specific question. Because in the bill, we say, because the service is free, you take the risk at your own, you take the service at your own risk. And then he was saying, we want, how do we protect communities? Protect communities from what? From malpractice, from bad advice and negligence. As a result, we have since met with the Law Society in terms of looking at modalities for creating a means of professional indemnity, and also to look at other means of conduct management. One, ACAOSA has got a disciplinary process internal, and also the new proposed council will also deal with questions of conduct. but we want also to look into this thing. We are right now researching this question of an indemnity scheme. But the difference here is that in the South African context, the cases are prevalent where malpractices are prevalent where money is involved, like road accident fund, etc. Community advice offices never handle money in our understanding. And so our ambit will be focused only on bad advice and etc. So we are at this point developing an indemnity strategy to say how indemnity provisions within the bill, how do we protect communities?
Great, thank you. Anybody want to speak to this question of systematically incorporating feedback from communities and clients?
Yeah, I just want to say, I mean, one of Gagan here.
Yes,
yeah,
please,
I
Gagan
just
bhai.
want to mention that we had, we had talk of one is at the selection stage itself. When we talk of community-based paralegals, they normally are thrown up by community-based organizations who say so-and-so woman or so-and-so should go in for a paralegal training and come back to the community. That's one. But we definitely always have a helpline. We have a monitoring system of their cases they have handled for quality. And if there are signs of corruption and things like that, then we take it up and make it into public and actually blacklist such paralegals into that space. The National Legal Service Authority, which hires paralegals, also has a complaint mechanism where if somebody is misusing their powers, that can be reported and the person is then blacklisted. So these are some systems which are getting into place, but the danger still remains when you start looking at huge volumes, that there will be a certain percentage where this thing will go wrong.
Great, thank you, Gagan bhai. I would just say from Namati's side that this question of client feedback has been a tough one for us. I mean, we had tried at different times to have boxes where people could put in a little feedback slip, but for various reasons they didn't really work. One being that it's awkward to have the paralegal right there and filling out a feedback slip. It's unlikely to get really frank answers. And literacy is also a challenge. And so one thing that we are just in the early stages of experimenting with is a systematic client follow-up procedure where in every country where we are involved, we're going to take a random sample of clients and go and visit them a set every single month so that we have a rolling, and then ask them about, have an hour-long conversation with them about their experience working with the paralegal, what difference did that work make, what was the impact of the case, do they have any feedback on how we could do better, and to be collecting that data on a rolling basis. It's sort of too early. We are planning on sharing learning from this, but we're not quite there yet. But if our friend from Tanzania or anyone else is interested now in seeing the instruments that we are using or the protocol that we are using, we'd be happy to share it. Not just ask you guys to reach out to us directly. Helen Lang was the one who had the question. We are running short on time, but I wanted to get a couple more. There was a gentleman from Bangladesh. Let's see. Shariarji from Bangladesh was asking about lawyers. How do you grapple with opposition from the private bar? Anybody want to speak to that?
Okay, can I take that?
Please.
In the South African context, this is how we did it. We basically established the common ground around the fact that community-based paralegals do not charge fees, and also we agreed that we are part of the access to justice value chain, in the sense that they are part of our referral systems, and we continue to engage with their national bodies or associations, and as a result, we have eliminated most, if not all, of the problems that we have been experiencing over the years with them. Thank you.
Thank you so much. Sokita, do you want to add anything to that question of grappling with opposition or resistance from the private bar? I know that that is something that you spent a long time wrestling with?
Definitely, and I think it's something every paralegal organization or potential program should prepare to grapple with, as long as you're pursuing formalization and recognition. And my view is that it mostly stems from ignorance, because members of the private bar do not know exactly the role of community-based paralegals or paralegals in whatever sector. So they always have the impression that the paralegals are coming in to muscle into our territory and all of that. And so for us, a combination of efforts helped to deal with the issue of private bar challenge, and these included doing op-eds about the role of paralegals and how they were relevant in the justice system in the country, and how they were different but complementary to the work of lawyers. And so over time, we were able to win them on side, and we got quite a bit of support from the private bar when we were pushing for the Legal Aid Act of 2012. So I think largely it stems from them not understanding exactly what paralegals would be doing and how it would be useful for their work as well. And so we managed to point that out in several engagements. So we had one-on-one meetings, we had op-eds and articles in local newspapers. There were radio and TV programs on paralegals and what they do and what they don't do. And so that really helped clarifying the role. And the last point would be the issue of money. And I think it's something we need to grapple with going forward, how to make paralegals sustainable, because the lawyers were very clear about paralegals not being able to charge a fee for their services. But then is it sensible in the long term, given what paralegals are being asked to do on an increasing basis? So, but these are some of the things that we had to put in place to overcome the argument on the private bar.
Thank you, Sankita. We're just going to run a few minutes over past 90 because we were a little slow in getting started. I had one last question for the three of you, which is that a sort of big picture question, which is that something that we haven't really mentioned today, but which is hard to ignore, is the rise of authoritarian and nativist leaders around the world. And I think that the three countries that we have represented here are not exceptions. President Kuroma, there's rumors that he might bend the Constitution and seek a third term. Prime Minister Modi has selected a complete nativist to be Chief Minister of Uttar Pradesh. Jacob Zuma's administration is being in the midst of a huge corruption scandal. And I guess I'm just my question to all three of you is, how does the rise of authoritarianism and nativism, how does that shape your approach to the professionalization of paralegals? Any of the three of you want to speak to that?
Yeah, I could do that quickly and then pass the mic over to the other two.
Okay, go ahead, Sankita.
Okay, I think it's relevant. When you look at the paralegal model, in the main, it's about deepening democracy. It's about putting power in the hands of people to hold the leadership accountable. And so the rise of authoritarianism really contradicts that notion and that work. And I think it's important for us, as we pursue recognition, that we want to make sure that even though we're asking for the state to confer recognition on paralegals, we do not stifle the movement because of that recognition. And so in the main, we have to be careful to negotiate clauses that guarantee the independence of whatever body that would be charged with formalizing and accrediting paralegals. Otherwise, we run the risk of getting recognition by the state, and then the state using that same instrument to stifle any sensitive paralegal program that equips people to ask questions about what they do.
Vivek?
Yes.
Yes, from the South African context, we say that paralegals, community-based paralegals and community-based advice offices are apolitical, non-partisan, but they operate in a political context. And therefore, they cannot avoid the political challenges. We are beginning to say now that one of the problems that is manifesting now in terms of how the whole project of deepening democracy that Sonkita is talking to and that we agree with is that we created democracy from above at a very high level.
That's right.
That communities were excluded in the architecture of the democratization project. And what we are beginning to see in South Africa is communities beginning to insert themselves forcefully into the discourse of the direction of the country. Advice offices, their role, therefore, is to assist communities to begin to engage, to provide information, to understand the law, and to use the law, which is why we are beginning to see that, whereas you are seeing somewhat of a collapse across the board in terms of the legislature and in terms of the executive, but you can see that our judiciary remains a key anchor in terms of holding our democracy together. And some of the cases, for instance, the case that involved a company called Net1 and around illegal deductions involved the work of community-based paralegals. There's a lot of work that is being done in terms of mobilizing communities to raise their voices. But what we are clear about is that to protect ourselves as paralegals, we must not ourselves be at the forefront, but we must put information at the hands of communities so that they can raise pertinent issues, and so that we can put power in the hands of people. Thank you.
Thank you, Sibongile. Gagan Bhai, a last reflection.
I'll just add, I think Kamsher said it so beautifully. I just think he's absolutely bang on there. But I would just say, overarchingly, where dissent is not going to be tolerated, we have to go back to the communities and also differentiate between the justice system and rule of law. And I think there is a slight schism there. And if we could get communities engaging in the understanding of rule of law, therefore we are getting a lot of our community-based paralegals to actually even do public legal education in schools. And I think that's the long-term investment that we have to make, and they get also a huge legitimacy when they work with children in schools.
Great, thank you. Okay, thank you so much to people from all around the world. It's a special thing that the technology allows us to have a truly global conversation. We've had remarks, we've had questions from Tanzania, Nigeria, Moldova, Mongolia, Canada, and we've had presenters from India, South Africa, Sierra Leone. What a special thing that we are able to come together around this common challenge that faces all of us. I would underscore the invitation Abby made at the outset to join the Legal Empowerment Network, which is really a community that we hope provides an opportunity to continue conversations like these. In fact, we had many questions that we weren't able to get to that came in, and we would love to take those to the Discourse platform, which is the sort of community discussions platform, which allows a space for us to pursue things like this virtually. And I would appeal to Gagan Bhai and Sibongile and Sonkita to kind of field some of the outstanding questions virtually on that platform in the next couple of weeks. I also want to give a shout out to our friends at Open Society Foundation, who are undertaking something really ambitious and important, which is they are trying through something called the Shared Framework on Legal Empowerment, they are trying to scale up and institutionalize community-based justice services in several different countries, and we will send some links around to more information about that effort after the webinar. And with that, I want to say big thanks to Sonkita, Sibongile, and Gagan Bhai, and thanks for everyone for dialing in and taking part from wherever you are, and look forward to learning from you and collaborating with all of you in the future.
Thank you very much.
Thank you.
Okay.
Yeah, lovely engaging with all of you. Take care. Bye.
Great.